This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
October 24, 2001, 4 of Jackson's fellow Nuremberg prosecutors spoke at the Jackson Center and at local schools and colleges. James Conway, Henry King, Bernard Meltzer, and Whitney Harris participated. Bernard Meltzer discussed personal memories of Jackson. This event was part of a 3-day celebration of the work of Robert Jackson and the American prosecution team, and brought a unique perspective to the war crimes trials. All participants agreed that the principle established at Nuremberg that aggressive war is a crime and that leaders of a nation who commit aggressive war will be held personally responsible for their actions was the most important principle. Nuremberg set a precedent for further war crimes trials. This symposium was more than history revisited. It demonstrated that the Nuremberg principles remain relevant to the 21st century.
I'm Greg Peterson. I'm the president of the Robert H. Jackson Center, and we're in the process of concluding an extraordinary week here in Jamestown, where many of the participants who were with Justice Robert Jackson at the Nuremberg trials came together for a little bit of a reunion and a little bit of a reminiscence about Justice Jackson and what he's meant to not only the law of international justice, but perhaps what his legacy is today. I am thrilled, absolutely thrilled to have as one of the participants, and somebody you'll have a chance to see through this distance learning process, Bernard Meltzer. Mr. Meltzer is a University of Chicago and Harvard Law School graduate, is the Edward H. Levy Distinguished Service Professor of Law Emeritus at the University of Chicago Law School. He's the author of Nuremberg Trial, A Prosecutor's Perspective, which appears in the Journal of Genocide Research. He was a special assistant to the chairman of Securities and Exchange Commission from 1938 to 1940. He served as legal consultant to the National Defense Commission until 1941. He was assistant trial counsel, United States prosecution staff with Justice Jackson at the International War Crimes at Nuremberg. Had an opportunity to present the economics case, which for those who are studying this, a very fascinating portion of the International Military Tribunal case, and also as part and parcel of that, had a chance to interview Hermann Goering, who you students probably have studied as well. His resume is exceedingly long, and I could go on for a long period of time. However, we do have a short period that we got to make sure that they make the flight out of Buffalo today. So without no further ado, Professor Bernard Meltzer. Thank
you. Is this working all right?
Yes, both mics are fine.
Both mics are fine. Well, I understand that I gave you some homework, and I'm assuming that you did your homework. The choice was between my doing homework and preparing something, and you're doing homework, and the choice was easy for me. Now, I thought just to refresh your recollection, I would remind you of the basic article which defined the law of the Charter, which governed the proceedings of the International Military Tribunal. Article 6 defined the crimes that were to be tried before the tribunal. And 6A proscribed and defined crimes against the peace, and that those crimes essentially were conspiracy to engage in aggressive war and engaging in aggressive war. And although those provisions had very broad scope, because read literally, they would have covered the private in the German army, they were aimed, of course, at the major architects and executors of aggression. Then Article 6B referred to war crimes And war crimes consisted essentially of violations of the laws of war and the customs of war, and those crimes included, but were not limited to, the lawyers were at work, of course, ill treatment or deportation to slave labor or for any other purpose of civilian populations or in occupied territory, murder or ill treatment of prisoners of war or persons on the seas, killing of hostages, plunder of public or private property, and so on. And then the final category of criminality consisted of the crimes defined in Article 6C, crimes against humanity, murder, extermination, and so on, committed before or during the war, or persecutions on political, racial, or religious grounds in execution of or in connection with any crime within the jurisdiction of the tribunal, whether or not in violation of domestic law. So those substantive provisions define the law which was binding on the tribunal. And with that refreshment of your recollection, I am now open to questions, and one of the phrases that help me from time to time is the phrase, "I don't know," and that may be quite evident this morning.
With your economic knowledge of Nuremberg and the quest for international law and justice, do you see the current freezing of terrorist assets as a response to the tragic events of September 11th as a correlation? Well,
I'm not quite sure what correlation implies. If it implies parallel situations, I think it would be useful to keep in mind the distinctions between Nuremberg and the situation involving Osama bin Laden. At Nuremberg, we had fought the war. The Americans had almost all of the potential defendants in custody. The other remaining defendants were in the hands of our allies. Germany was prostrate. The German people had no energy. No one had to be concerned about Germans being inspired to be martyrs. No one thought that the Germans believed that killing either American soldiers or American civilians was a passport to paradise. In addition, there was no problem of arousing the large number, or that was a counterpart of the problem of arousing large numbers of Muslims. So the situation, although it has some similarities, involves substantial distinctions from the situation at Nuremberg. There is one parallelism, and that is, in both cases, the Americans and our allies were confronted with imperfect choices. One possibility, as you all know, which the British adhered to until very late in the war, was to line up 25 or so of the chief Nazis and shoot them. Summary execution, no pretense at trial. The Americans objected to that. The British relented, but they relented only after Hitler and Goebbels had killed themselves. So the British went along in part because of American pressure, but in part because the potentially worst troublemakers who might have turned the trial into a soapbox for their propaganda, that is to say, Hitler and Goebbels were no longer present. When we turn to the other alternative, the one that actually was used, the trial, there were problems, in part because the key provision for Mr. Justice Jackson was the provision outlawing aggressive war. While sitting there on the courtroom panel with us was the representative of the Soviet Union. And the Soviets, of course, had taken a bite out of Poland in connection with German aggression. The Soviets had also swallowed up the Baltic states and had invaded Finland. But here was an ally which had suffered enormously and which we hoped would collaborate effectively and peacefully with us in the post-war period. And the question was, should it have a place on the tribunal? And the answer was yes, even though we understood that the Soviet presence compromised, in one sense at least, the tribunal and the provision that outlawed crimes against the peace. Now, with respect to bin Laden, we also have a set of imperfect alternatives, but I think I'm going beyond the scope of the question, so I will stop here and perhaps come back to that point later on.
My question is related to Jackson's insistence about that the trial was not victor's justice.
I'm sorry, I missed that. The trial
was not just victor's justice, and Jackson believed in the morality and validity of the trial. My question is, if Jackson would have kept this belief if the Germans, if the tables were turned and the Germans put the Allies on trial for waging aggressive war crimes, crimes against humanity, illustrated by such acts as the invasion of Poland, the bombing of Dresden, Hiroshima and Nagasaki, and the global mistreatment of POWs by all countries more.
I'm not going to pretend to speak for Justice Jackson, but speaking only for myself, you've put your finger on the central difficulty of the trial. It was victor's justice. The choice was, of course, between victor's justice or no justice at all. And you put your finger on another aspect of law. In one sense, law is designed to restrain power. In the opposite sense, law cannot be enforced without power. Now, victor's justice was not the product of Nuremberg. Victor's justice was the product of a fragile, undeveloped system of international law. So in the end, the issue was victor's justice or no justice at all. Summary execution without a right to defend yourself, or no penalty at all, unless the German people followed the Italians. You know what happened to Mussolini. And one of the purposes of the trial was to avoid the indiscriminate bloodbath that might have resulted if the anguish, disappointment of the German people had not been channeled into an orderly proceeding. So that I don't know what the answer would have been had the tables been reversed. My hunch is that the leaders of the defeated nations would not have had the luxury of a trial, that their disposition would have been summary execution. But you've pointed, as I said, at the fundamental difficulty, and it is one that will persist until we can develop institutions with enough power to deal out justice without regard to whether those in charge are victors or neutrals, and neutrals are never easy to find whenever there is a war. And you've put your finger on another important point, which was the point that moved Mr. Justice Jackson to make the central tenet of the trial the prohibition against aggression, because all of the difficulties that you imply are the consequence of an aggressive war. At least that was true in the case of the Nazi system. Now, when we get to genocide and tribal warfare and so on, there are other problems. But fundamentally, under conditions of modern technology, in a sense, the greatest crime against humanity is the launching of an aggressive war.
Yes, Professor, without the documentation that was available to us regarding the Nazis, should we arrest these so-called terrorists today, and we don't have documentation, will it be difficult for us to conduct a trial similar to the Nuremberg trial?
Well, I don't know what evidence we have, but surely without documentation it will be difficult. If you have a trial, you presuppose the possibility of an acquittal. If you have a genuine trial, not a show trial, I think our alternatives, again, would be imperfect if we captured Osama alive. Now, for me, the happiest conclusion would be if Osama died an honorable death in battle. But if we capture him alive, we have said we would give him justice. And justice, particularly given the precedent of Nuremberg, implies a right to defend himself. So there are risks in a trial. And if Osama should be tried and acquitted, the increment to his prestige and power within the Muslim world would just be increased exponentially. And that is one of the risks. And if we think of the various kinds of trials and various participants, the question is, how do we achieve a fair trial and reduce the risk of a judgment or dissent based not on the evidence, but based on values or political considerations that we would consider irrelevant, indeed illegitimate. And we can speculate about that. As I think I said earlier, the problem of how to handle the defendants was an acute one in connection with Nuremberg, and the British acquiesced in the trial only at a very late date. So I don't know how much time we have to ponder these issues. One issue that I would like to see explored, maybe John has already explored it, is what are the limits of a military tribunal? Could we set up a military tribunal which would be fair but more controlled than a tribunal established by some international organ, or a tribunal in which we decide in the hope of not alienating Muslims to have a Muslim judge? I myself don't think that the participation of a Muslim judge would make any difference with respect to committed Muslims. In Yugoslavia, for example, the Serbs, from the very beginning until the end, thought that the tribunal was biased, was an instrument of Western power, and not an instrument of justice. And that was true even though the judges and the prosecutors came from areas quite remote from the Balkans. So there are grave difficulties here, and perhaps we rely on one element of the common law tradition, don't decide today what you may be able to postpone until tomorrow.
Professor Meltzer, should nations use their own courts to try past leaders who have been accused of violations such as crimes against peace or humanity?
That's a very general question, divorced from any particular context. And another principle of the common law is to worry about the the grubby details that provide context and texture to a problem. But so I would say, in some cases, yes. In other cases, the domestic institutions are not capable of dealing with the problem. In some cases, neither the existing international institutions or the domestic institutions are capable. In Rwanda, as I understand it, you have 500,000 suspects without a judicial infrastructure, and so some of the Rwandans concerned either with justice or with different values implored the international institutions to help them do the job. But if the national institutions are regular, honest, and competent to do the job, and there is no problem of alienating people who are the concern of the national government, then by all means, I think the national institutions should do the job. But as I indicated earlier, it is difficult to deal with that question as an abstraction because there are so many forces, internal forces, indeed geopolitical forces, that may come into play and help shape an answer to a difficult question in a given set of circumstances.
Might we ask your position on the Rome Treaty, Professor?
Well, I'm really not an international lawyer. I just happen to be at Nuremberg. You may ask, and I may duck. But my position on the international treaty is that when you deal with issues of the kind that may come to a tribunal, those issues cannot be divorced from politics, and I mean politics in the legitimate sense of the word. So I am sympathetic to the American position that wants the Security Council to have a hand in the inception of prosecutions. If you can get the unanimous consent of the great powers, you can come closer to avoiding judicial proceedings that may disrupt a fragile peace, that may impair a geopolitical equilibrium, and so on. Now, there is, of course, a cost, and this is an imperfect alternative. But there are also some other benefits. When I say there are legitimate political factors, I want also to emphasize that if you are a prosecutor, you have one function, find the bad guys in the interest of equality, the bad women, and pursue them and bring them to justice. But even in our own system, on some issues, there are legitimate concerns in which the executive, the president, who responds to general political factors, may influence the Department of Justice. Now, I know I'm going against the conventional wisdom. Most people who are at Nuremberg think that the logical next step is an international tribunal, and they're concerned about the Security Council. They do point to the fact, they do point to the fact that the Treaty of Rome does have a provision which permits the Security Council to stop proceedings for a year. But I assume that the veto power would apply to that decision. Well, under the American position, the veto power would apply to the institution of proceedings, and the U.S. could stop that. And the U.S., of course, has perhaps the greatest number of soldiers in foreign climes, and the Pentagon is concerned about unjust accusation in trials. I myself don't think that is the dominant difficulty. I think the dominant difficulty arises from the attempt to divorce legitimate political considerations from an international judicial process. And there is no perfect mechanism for bringing about the right adjustment, but at least the Security Council may avoid a trial being the trigger for animosity among the great powers. Now, that's confidential. Please don't tell Whitney Harris or Henry about this. But you may. I've told him.
Why was the U.S. the only prosecuting country in the 12 so-called lesser trials in Nuremberg?
Well, I don't know. I left right before the main trial ended. I think that each country decided that if it dealt with defendants or prospective defendants in its own zone, you'd get on with the business. I'm not sure why the coalition decided to go its separate way, but it may have been in the interest of expedition. The IMT, although it was remarkable in its expedition, did take much longer than Justice Jackson, for example, expected, or that the Chief Justice wanted. So that if you maintain the international format, the question is, what would happen to the staff? So if you had new separate proceedings, you could start with a new staff, and each country could recruit in its own way, and you had the basic doctrine embodied in the charter, ratified, clarified to some extent by the judgment, so that there was a precedent and there was a body of experience that could inform the work of the individual national prosecutions. But precisely what the decisional process was and what the decisive considerations were, I don't know.
Earlier, you talked about problems in divorcing yourself from political ties and being a judge. Isn't that the basis of America's judicial system? That the judge is impartial? If they were affiliated with a political party, they could easily not let that influence their judgment.
That certainly is a tenet of our system once something gets before a judge. But the question of whether something is ripe for judicial consideration may involve political considerations, legitimate political considerations that I mentioned. And indeed, it may be that the very fact that the judge should exclude political considerations once the issue comes before him, that very fact, that great aspiration may underscore the importance of some other body taking account of legitimate political consideration. Yes, sir.
What are the difficulties in combining so many different legal systems at the international level?
Well, there were difficulties, but I think good sense and a desire to reach workable compromises made it possible to adapt different elements of each system and come to a consensus about the procedural framework. There were some difficulties in application because the only prosecutors who had any experience with cross-examination were the British and the Americans. In the French system, the judge does most of the questioning. The judge is a much more active figure than the American judge. He may be in charge of what we call discovery. He examines the witnesses. The lawyers may have a shot at it, excuse me, but the judge is the dominant figure. In the Soviet system, the indictment had a lot more detail than the American indictments. But in the Soviet system, of course, in political trials at least, typically set forth the details in the indictment because they expected most defendants, for one reason or another, to plead guilty. So there was all spelled out in the indictment. Those procedural difficulties, potential procedural difficulties, didn't ripen, in part because the British judge was very skillful, and in part the general tendency was to lean backwards in favor of procedural fairness for the defendants.
Should we become involved in an international court, and if so, at what level?
You mean in general, the standing court? Well, it's not only at what level, it's with what charter, with what restraints. I think it would be a good idea for us to be involved. I think one of the costs of not being involved is being charged again with unilateralism and so on. On the other hand, we must think hard. We must engage in a kind of cost-benefit analysis, and I believe if we have the court as an instrument of the United Nations, and if the Security Council has a role in fundamental decisions, that it would be a great contribution to have a standing court. There are always problems of how we're going to pick the judges. As I remember it, the judges are to be picked by a vote of the parties that agreed to the basic covenant. Well, I read the other day that there are 56 Muslim countries. I don't know whether they would be a voting bloc. So the devil here is in the details. And given my angelic nature, I have not studied all the details. But I think it's very important to look at questions of who selects whom, what are the possibilities of having the wrong folks in decision-making positions, and so on. But in principle, I think it would be a great contribution of the United States after looking at its interests, join an international court.
Question at Southwestern?
The Nuremberg Trial concluded that even if an organization acted in a criminal way, the members of that organization could be tried.
Wait 1 second. I'm going to try to get you a little adjusted here. We're going to ask you to repeat yourself in just a minute.
We need an electronic psychiatrist.
Okay, there may be a temporary echo, but go right ahead.
The Nuremberg trials concluded that even if an organization acted in a criminal way, the members of that organization could be tried because they participated on a voluntary basis. Can we then assume the guilt of a 13 or 14-year-old boy who was recruited into an organization such as Al-Qaeda?
I think you left out one element that was imposed by the tribunal's judgment. It was not only voluntary participation, but also with knowledge of the criminal purposes of the organization. Now, at what point in time we charge an adolescent with a capacity to understand the nature of an organization is an interesting question. Surely his youth could be a factor in mitigation, and this slides into questions that have troubled our own national system. May the young be tried as adults. May the young be executed. May the retarded be executed. So far as I know, that issue was not tested in the proceedings that followed the rendition of the judgment by the tribunal. But it certainly is a good and puzzling question.
How will the terrorists have the luxury of a trial?
How will they have it, or should they have it?
Both, I guess.
That's good.
Well, what you call the luxury of a trial, some of us call due process. And I think the president, by implication, at least, has indicated that if they are captured alive, they will have justice. And justice implies the right to defend oneself. So, speaking generally about a trial, without trying to cabin in all of its details, I think if we are not fortunate enough to be able to avoid that problem, the terrorists, if captured alive, should have due process, or as you put it, the luxury of a trial.
We know that countries such as China are guilty of violating human rights. Are our leaders guilty of not taking a stand against these countries?
Well, we have taken a stand against the violation of human rights, but you've put your finger on one of the great difficulties of achieving equal enforcement of humanitarian law. In order to vindicate all of the humanitarian laws that have been adopted by the nations, when a country like China, we assume, has violated them, what do? Well, we might engage in an economic boycott with great suffering in China, and when the dislocation of all our young people who like to buy fancy sneakers at not too expensive prices. The other alternative, of course, is war. And the ultimate point that I think you are illustrating is that while justice tries to restrain power, the existence of power is a necessary predicate for the instruments of justice to do their work. And the question of what pressures you exert against a country that is deviating from either our norms or international norms is really a political question of the highest order, and I don't think we can deal with it as simply a question of whether or not we enforce the provisions or achieve the aspirations of humanitarian law. I didn't hear that.
Did the gentlemen at Nuremberg that were found guilty, did you feel that they showed remorse at the end?
Here again, it depended on which individuals. Speer showed remorse. Hans Frank, who had been Governor General of Poland and I think Attorney General at one time, I'm not sure, said something like this: 1,000 years will not erase the guilt of the Third Reich. I think the military on the whole felt they were being abused. And I don't know about the foreign minister. There are two really related questions. Did they feel remorse and did they show remorse? And obviously we could have a more objective notion of whether they showed remorse, but I saw them only in the dock. There were psychiatrists who dealt with them, and my recollection of their findings was that some of them showed remorse. Certainly Goering was unrepentant to the very end, and Schacht was not found guilty, but he thought one of the greatest abuses was to have put him in the prisoner's dock. So you had a whole variety of reactions depending in part on the role and the actual as distinguished from the admitted knowledge of the defendants concerning the atrocities that were exposed by the evidence at Nuremberg.
A follow-up to that question, how, when you were in Germany, did you separate your feelings from the German people and the people you were prosecuting of the Third Reich?
Well, several ways. One, we had a strict no fraternization policy, but we saw destruction all around us. So that in a sense, the devastation of Germany was another affirmation of the importance of Justice Jackson's conviction that the supreme crime was aggression itself and not the violations of the laws of war and the agonies and the atrocities that are connected with all wars. We were quite conscious of the devastation, at least I was. And the other way of separating yourself was just the rhythm of your own work. There were these documents that were flowing in, and they had to be read and organized and so on. And the lawyer's craftsmanship took over. You and your unit had certain things to prove in support of the indictment. The lawyer's question is, how do we prove it? And you became absorbed in that professional task, and that shut out a good many of the concerns that you had initially. And those concerns were many. I've said to some of our other friends here, my first shock when I came to Nuremberg and had a meal was when somebody said, in reply to my question, well, you tip the waiter 3 cigarettes. Cigarettes became the coin of the realm. And you are shocked by it initially. In a week, you are used to the new currency. So in time, you get used to the devastation, sites of devastation, and on the other hand, you are being reminded each day by the documents and the photos that flow in. You are reminded of what the representatives of these people, although you were not indicting the people, what those representatives did to civilization in Europe, outside of Germany, and indeed in Germany itself. So all those things operated to have you concentrate on your professional job.
There's approximately 5 minutes left in the broadcast, and should we go off abruptly, I just wanted to let everyone know that that was scheduled to happen. We're ready for our next question.
Sir.
Regarding the actual executions at Nuremberg, I know many of the Nazi officials were quite incensed by the fact that they didn't get a choice between being shot by a firing squad or being hung. And I know they thought the military way to go would be shot by a firing squad.
Exactly.
Do you think they should have had that option?
You're appealing from the tribunal to me, is that it?
I'm just asking here.
Well, I think you have to put yourself back into the context. There are 50 million people or so died as a consequence of the war. The people of the occupied territory thought that capital punishment, even by hanging, was too mild a penalty, that there should have been torture before death. And there was a worldwide revulsion generated by the evidence of the concentration camps, the extermination, gypsies, Jews, the mistreatment of Slavs, and so on. And the use of the noose rather than the firing squad was a way of saying to the military, you did not carry out your fundamental responsibilities, which was to respect the laws of war. You should not have followed orders to kill British flyers, to kill POWs, and so on. So that, in a way, the form of execution was another indication of why it was that the military was in the dock in the first place. So given both the outcry from the world and what we were saying to the military by trying and convicting them, the use of the hangman rather than the firing squad was quite compatible with the larger purposes of the trial. But I have to say, I never gave it much thought at the time.
Americans have come to expect almost total media coverage of unfolding events. How does that compare to the Nuremberg period?
It was a question that we've become used to getting immediate media coverage of every event, and how does that compare to the release of material from the Nuremberg trials?
It's hard for me to make that comparison because the media that I was conscious of when I was at Nuremberg was the German media, so far as instantaneous communication was concerned. The German media followed the trials. I did get delayed communications from people in the States. My understanding is that after an initial burst of attention, the American media was turned off by documentary evidence. It's not exactly some order from one general to another in semi-code was not exactly the raw material for a sensational lead into the 5:30 news. So that my hunch is, as the trial proceeded, except for dramatic incidents such as the cross-examination of Goering by Jackson, the attention of the American media began to fade. But I have no first-hand knowledge of that. And today, of course, we have competition between the print media and the TV and the electronic media, and everybody's anxious for a scoop, and there is something closer to home in the events that have occupied the media recently than was true of a trial across the Atlantic Ocean. Sir.
At a trial taking place before Nuremberg on an international level, how do you think that would have changed what actually took place at Nuremberg?
Well, that would depend on what the trial had found, what the charter was, and so on. There's so many imponderables there, and even if we knew the imponderables, we would have to speculate on their impact. It's an interesting question about the role of precedent and so on, and whether an earlier precedent is distinguishable by the facts of a new situation. But I think it's very hard for me on that abstract level to deal with the question in greater detail.
Now, we had two questions that came up simultaneously. I have one in Panama, and then I have one in the back here at Jamestown. So let's go to Panama, please.
Everyone here has a definite knowledge of the horror and genocides committed by the Nazis brought to air at the Nuremberg trials. It's only a few, though, that can probably say that they have a knowledge of the atrocities being committed today in countries such as Cambodia, Rwanda, and Egypt. How will our generation raise the consciousness of such instances so that crimes of silence may come to an end?
Well, I think we're making a beginning here today. That is to say, this may, like patriotism, be the last refuge of the uncertain, but obviously, somehow or other, we have to, by education, increase the respect for human rights throughout the world. That's a very tall order because there's so many different traditions, there's so many hatreds, there's so many rivalries. We don't have to go to Cambodia. We have to go only to Northern Ireland, which is heir to some of the great legal traditions, and yet what we can call the analog of tribal and religious rivalries have disrupted the peace for generations. So I have no easy solution for what is a real problem, but we have many institutions. We have declarations of the aspirations reflected in various covenants, which may or may not have a real impact. We have various organs of the United Nations. We have religious institutions. We have exchanges between countries. And we just have to plug away at a difficult question at every front that's available. But we know throughout our long history there are many problems, the solution to which still eludes us. That doesn't mean we despair, but we have to be perhaps content with incremental victories and hope that this generation and the next one will do better than their predecessors.
If Hitler had lived, how might he have been prosecuted?
Oh, I think he would have been the key defendant. And then I think we would have gotten more press coverage. Yes, indeed.
Would it have caused a nightmare, Professor, had he gone?
I don't know. It's hard to tell. By that time, he was distraught. By that time, look what happened to Germany. Look what happened to his dreams, which were the nightmares for the rest of us. So, and he might have thought, what did he have to lose if he defended? He would have gone back to Versailles, and he would have blamed it all on the Allies. Sir.
My question is, what were the effects on Jackson's psychologically and emotionally after his cross-examination of Goring, where many thought Goring kind of got the better out of him when he was on the stand? And what were the effects on the tribunal after Goring's suicide?
Well, first, I would have to speculate. It was not, as you imply, one of Jackson's best days, but if you are a litigator, as he was, you have to learn how to take defeat or a partial victory and go on and do your job, and he did it. I'm sure it was a great disappointment for him, in part because there were technical criticisms, justified or not, of how he went about the job of cross-examination. And his method was sharply different from that of Sir David Maxwell Fyfe, who was the operating head of the British delegation, who's an experienced, distinguished barrister. He asked very narrow, tightly controlled questions, and that made it very difficult for Goering to make broad statements about Nazism or about the obsolescence of the laws of war or about the Germans not doing anything differently from what the Americans had done, and so on. So I think it was a defeat, and I think for Jackson, but that defeat was overshadowed, I think probably in his own mind, certainly in the minds of other observers, by the magnificent eloquence of his opening statement and other parts of the trial in which he did nobly.
Now the Southwestern, I thought you had a question and I maybe didn't catch that. This will be the last question as we're moving toward 10 o'clock and Professor Meltzer's need to get to an airplane. Was there a question at Southwestern that I didn't catch a moment ago? I would assume not. Any final questions? We do have room for one question. Well, I guess, I don't know, go ahead. You had your hand up first.
Were there any people who were convicted at the trial who you think should have been acquitted?
Sorry, Mr.
Were any of those convicted people that you believe sitting there might have been acquitted? Perhaps should have been acquitted? What do you think, Justice?
No, I don't, but people who have read the record carefully, such as Telford Taylor, believe that Stryker, who was a very unpleasant propagandist, had such little power at the end that perhaps a capital sentence for him was extreme. You know, the problem of balancing sentences when you have crimes of such enormous gravity is a very delicate and difficult one.
Thank you. Professor Bernard Meltzer.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg Trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.